Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to go back to the ongoing saga as it relates to suppressors, but we're not going to be talking about what's going on in the Senate or the House. We're going to leave that up to other people. And we're still a long, long way from getting that reconciliation bill to where it needs to be. But as there is all this evolution occurring as it relates to the regulation of suppressors, we have to remind ourselves that there was an opinion out of the Fifth Circuit that actually said that suppressors don't constitute arms at all and therefore are afforded no Second Amendment protections. Well, it appears that there has been a significant and seismic shift out of the Fifth Circuit on that issue. We'll explain what happened. We'll explain how we got there in just a moment. So today, let's spend a few minutes and let's talk about a major development in the suppressor saga. Okay, America, everyone seems to be in tune with suppressors lately, predominantly because, as we know, there is a huge push underway to get the Hearing Protection Act incorporated into the Reconciliation Act, translation, Big Beautiful Bill, and there is an opportunity here to remove suppressors and possibly even short barrel rifles from the purview of the NFA. There are plenty of other people covering the day-by-day activities on that stuff. We're going to leave that to them. What we're going to talk about today, though, is a significant development that has taken place in the Fifth Circuit Court of Appeals in a case that we have talked about before called United States of America v. Peterson. You may recall that Peterson challenged the constitutionality of the federal regulations on suppressors before a three-judge panel of the Fifth Circuit. Somehow or another, though, we ended up getting an opinion out of a three-judge panel in the Fifth Circuit that said, hey, you know what? Suppressors don't even constitute arms at all, and therefore are afforded no Second Amendment protections. Now, we found that really odd that suppressors wouldn't constitute arms since they are actually defined by federal law as a firearm, but I digress. But that obviously had a lot of people really freaking out. And this is the thing I need you to understand, America, as we're going through whatever we're going to go through with suppressors here, is that I get that a lot of you think that there should be no federal regulations of suppressors whatsoever, that we can just walk into any sporting goods store and just buy one off the shelf. I'm not saying that's a terrible idea. What I am saying, though, is if you live in certain states, and if that were the status of law, I could flat guarantee you that you would see a multitude of states flat out ban possession, sale, offer for sale, or use of suppressors. And so therefore, for some of us that still live in these civilian disarmament states, having even a little bit of Second Amendment protection is better than none. Well, after the three-judge panel in the Fifth Circuit found that, well, there really is no Second Amendment protections to suppressors whatsoever, Peterson then moved for a full OnBan review. Now, understand that getting a terrible Second Amendment ruling out of the Fifth Circuit is, in fact, pretty rare. It's not as rare as getting a good Second Amendment ruling out of the Ninth Circuit, but it is definitely unique. And so there was obviously always a chance that Peterson could do much better before the full panel of the Fifth Circuit. Well, the United States government, between the time that they successfully argued Peterson and the time it came up to decide whether or not there was going to be an en banc review, they had a seismic shift as well. That began back in November of last year when President Trump won election, and then continued as he instilled his new Department of Justice, including the inclusion of Pam Bondi and ultimately the executive orders as it related to protecting Americans' Second Amendment rights. That then led the United States Department of Justice in filing a memorandum in opposition to the en banc review, because they are still claiming that no, the court got the right ruling, but they are now saying that you might have got the right ruling, but you might have got it for the wrong reasons. Specifically, the Solicitor General for the United States Department of Justice pled to the Fifth Circuit. A panel of this court affirmed, holding that the registration requirement does not violate the Second Amendment because suppressors are not arms protected by the Second Amendment. Peterson petitioned for rehearing en banc, and the United States opposed, arguing that the panel's decision was consistent with the Supreme Court precedent and the decision of other circuits, which is actually not really consistent with anything. But then the United States Department of Justice does a little bit of a mea culpa. As part of its broader evaluation of its litigating positions in Second Amendment cases, see Executive Order 14206, protecting Second Amendment rights, the United States has reevaluated its position in this case. In the view of the United States, The Second Amendment protects firearms accessories and components such as suppressors. Okay, that is huge because the United States Department of Justice is basically saying, hey, listen, we're coming off that position, and since we're coming off that position, we don't believe that the court should have made that finding at all. DOJ then went on to further plead. As a result, restrictions on the possession of suppressors burden the right to bear arms, and a ban on the possession of suppressors or other similar accessories would be unconstitutional. This is huge. I want you to understand this is huge, America, that this is the position that the United States Department of Justice is seeing. Because if, in fact, there is a deregulation to some degree of suppressors in the Reconciliation Act, mark my words, all of these states right here on the Dirty Dozen list, at least those that don't already have suppressor bans, that will be item number 1 in the state legislature starting next legislative session. DOJ goes on to further state, the government's earlier argument to the contrary was incorrect, but the National Firearms Act's registration and taxation requirement is constitutional because it imposes a modest burden on a firearm accessory that is consistent with this nation's historical tradition because suppressors are especially adaptable to criminal misuse. Okay, now the United States Department of Justice has kind of lost this here because I wholeheartedly disagree with that last statement. And this whole modest burden, that sounds to me like we're getting back into a balancing test. And so what the United States Department of Justice is doing here is they're saying to the Fifth Circuit, listen, you guys got the right result, but you got it for the wrong reason. And the reason you should have got it, as they put it, is, for this reason, the panel correctly affirmed Peterson's conviction. Accordingly, although rehearing en banc is unwarranted, the court should grant panel rehearing to correct the panel opinion's analysis. All right, so the United States Department of Justice is asking for a rehearing en banc just to address the correct analysis, but they're still anticipating the same result. But earlier this week then, after the United States Department of Justice filed their memorandum on June 17th, we get this incredibly brief memo from the Fifth Circuit Court of Appeals that states, pursuant to the court's directive, the opinion in this case has been withdrawn. What does that mean? It means that this 3-judge panel ruling by the Fifth Circuit that said that suppressors were not even covered at all by the Second Amendment no longer exists. That opinion has been withdrawn. Whether or not a 3-judge panel is going to amend their opinion and reissue it, or whether or not this will proceed to an en banc proceeding, remains to be seen. So America, understand that there is a significant shift underway right now as it relates to the Second Amendment and who's defending it in the United States right now. And one of the biggest allies that we have not ever really had on our side now is the United States Department of Justice. And we have seen in relatively short order that when DOJ weighs in on issues, they seem to have a considerable amount of persuasion. Now, I don't know what's going to happen with this Peterson case. It could be given an en banc ruling. Maybe the 3-judge panel comes out and says, okay, on a do-over, he still loses, but he loses for these reasons. And then where Peterson goes from that remains to be seen. But understand what the dangers would have been had there actually been published precedent out of the United States Court of Appeals that said that suppressors are afforded absolutely no Second Amendment protections whatsoever. That would have been a major, major problem, especially if you live in one of these Dirty Dozen states. So kudos to the United States Department of Justice for at least partially correcting the record. The case, once again, is the United States of America versus Peterson. We're going to go ahead and link up all the information down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.